7 o'clock, and I'll call this meeting to order. Mr. Gibbs, will you please read the statement of compliance?
In compliance with the Open Public Meeting Act, Public Law 1975, Chapter 231, notice of this meeting has been properly advertised in the Daily Record and Suburban Trends. Its agenda has been posted at the appropriate locations, and a copy has been filed with the Pequannock Township Clerk.
Thank you. Please call the roll.
Mr. Bloomer?
Here.
Mr. Cerisi?
Here.
Ms. Dempsey?
Here.
Mrs. Esposito?
Here.
Mr. Gittin?
Here.
Mr. McSweeney will be late. Mr. Pompeo?
Here.
Mr. Senek?
Here.
And Mrs. Shannon.
Here.
We have a quorum.
Thank you. Will everyone please stand for the flag salute? All right, good evening, everyone. Welcome to our June 24th regular business meeting. Tonight, the board will receive a presentation on school safety and HIB reporting, as well as another by our board attorney on relevant legal issues. The end of the school year has arrived, and I want to congratulate all our students that have moved on or that graduated last week. I was able to attend the promotion ceremony for North Boulevard, the graduation for PV, and I was privileged to speak at the PTHS graduation. It was great to be able to see the enthusiasm on the students' faces as they were promoted or accepted their diplomas. Additionally, I thought each ceremony that I attended was very well organized, well run, and emphasized the importance of those special moments for our district families. Great job to all the faculty, staff, and administration on executing these events, and congratulations to all our students and families who took part. I hope that all our students and staff have a very safe summer, fun and relaxing summer. With that, I'll pass the mic over to Dr. Portis.
Thank you, Mr. Senek, and to echo your sentiment, thank you to everyone who helped make our PV and PTHS commencement ceremonies such successful events last week. Staff, students, administrators prepared exceptionally well and helped provide a memorable evening for our families and guests. The buildings and grounds team and custodians made sure that our facilities were in good order. Our security team collaborated with the police to ensure the safety of our guests, and our EMT squad was there to provide another layer of support in the event that the heat became too much. And I will say it was pretty hot both days, but it was manageable and it was really nice. I'm proud to say that both events were joyous and respectful celebrations of the people who helped to make our school district such a wonderful place. And I know I said that in my last two updates I've sent out to the community, but I think it really bears repeating. I've been to a lot of high school graduations through the years. I've been doing this for 27 years. And I would say the combination of what I saw at the middle school and the high school, probably the two most dignified and refined events. Like I've seen graduations that seemed like they were straight out of Faber College, you know, the parade, but they were academic, they were fun, and they were just a real celebration of the work that our families were put in, that the kids have put in, that staff's put in. So I was particularly impressed and I really enjoyed it. Two other quick just notes. One is that summer hours begin today, which means that buildings are open from 7:30 to 4:15. The one exception, and closed on Fridays. The one exception there is North Boulevard will be open in July on Fridays for the extended school year program. District will be closed on July 4th, which is a Thursday, and remain closed on July 5th, which is a Friday, except for North Boulevard. And then finally, we're looking forward to the admin retreat on July 17th and July 18th, during which we will focus on analyzing data on student performance, as well as data on non-academic indicators, which actually is part of what Ms. Abrams is presenting tonight. We're also going to get some legal training, work on setting our goals, and also spend some time on some team building, as well as welcoming one of our newest members who will be celebrating her birthday on July 17th. No more fun than celebrating your birthday with Michael Portis at a district level retreat. Yes, I'm an absolute gas. So that concludes my superintendent report. The students are not here as they are on summer vacation. So I will actually pass the floor over to Ms. Abrams, who's going to present the SSDS report.
Hello, good evening. The Student Safety Data System, I'm so excited I'm tripping over my words, I'm sorry. The Student Safety Data System, SSDS, collects data from district schools in two main areas. The first area encompasses reports on incidents including violence, vandalism, harassment, intimidation, bullying, HIB. weapons and substance offenses, restraint, seclusion, other incidents leading to student removal. The second area is information concerning HIB training and programs. So here are the district-wide figures for those incidents. And just to be clear, that would be from, excuse me, sorry. That would be from July 1, 2023 to December 31st, 2023. Okay. Here is the school-based breakdown with the elementary schools listed first, followed by the middle school and the high school. So during this period, all efforts to support anti-bullying initiatives in district schools are recorded and reported to SSDS. And trainings are structured and activities that provide individuals with the skills needed to implement a program, strategy, or responsibility effectively. So programs are coordinated activities, systems, or scheduled events intended to help the community achieve a particular objective. So this is the breakdown on the trainings and the programs. This is the longitudinal data on total incidents in the district for period 1. And that's again, July 1 through December 31 in the past 6 years. Please keep in mind that in the past 2 years, data on seclusions and restraints have been reporting requirements. But in the previous 4 years, they were not. So more granular information will follow. So here is the longitudinal data on violence with a downward trend between last year and this year, as you can see. And I've also, broken it down for the school level, and this is consistent with the rest of the slides as well, so that you can see year to year. Okay. As it relates to vandalism, there were 2 incidents in period 1 this past fall. Oh, I'm sorry, because you don't really need to see on the side on the curtain there, but you can see the slides there, I think, on the right. Sorry. Okay. Yes, you do have the slideshow. Okay, good. As for the data on substance abuse, I am anticipating questions given the notable increase in incidents. One reason for this uptick may still be pandemic fallout, self-regulation challenges, possible exposure to trauma, lack of structure and predictability might have led to potential substance use as a coping mechanism. What I do want to be sure to emphasize with you all is that our new student assistance counselor, Ms. Basilone, since coming on board here at the end of April, has immersed herself in designing an action plan. So we also want to keep in mind, Ms. Basilone was not with us in this period of this reporting. We did not have a student assistance counselor at that time that was, staffed here in the building and dedicated to that. So Ms. Basilone, since coming on board here at the end of April, as I had said before, has immersed herself in designing an action plan. The acronym for her action plan is SBIRT. Screening, brief intervention, and referral to treatment. So this is an approach that's used to identify and intervene early with adolescents at risk of substance abuse. Okay. There were 0 incidents of weapons this past year, and the longitudinal data on weapons for period 1 shows 1 isolated incident in the last several years. Here is the longitudinal data for confirmed HIB cases, July to December. And this is the longitudinal data on alleged HIB cases. finally, incidents leading to removal are events not meeting the criteria from the previous slide, but they still result in a student being removed from their educational placement for half a day or longer. And as regards incidents leading to removal, there is a downward trend in the longitudinal data overall. Note that the high school has significantly higher numbers, but remember, and I also said this in the fall as well, remember that removals can happen for various reasons and in various contexts. For example, at the high school level, incidents leading to removal may result from students having multiple tardies to school, then not reporting to detention, and then that escalates to a suspension and to removal. And so these might not be isolated incidents that immediately lead to removal. They might escalate to that as a result. Okay. And then the last slide is newer for reporting, as I had said before, the seclusions and restraints. So the longitudinal data to share is really only for the last 2 years for that. And that is all. Any questions?
I have a couple questions.
Yes.
So my first is going back to that substance slide.
Yes.
Do we have a breakdown of, do we even know what substances it is that we're talking about? Because you would potentially action plan slightly differently depending on what
I'm
it
sorry, I'm
is.
trying to get the slides to
good.
go back. Mr. Schultz, could you move the slides back? I don't know why I can't move them back. So to answer your question, I did consult with Ms. Milner, who did look, take a deeper dive into that data. Not surprisingly, most of those substance, use incidents are vaping related.
Thank you.
Yeah.
And then another question sort of along the same lines, but slightly different. The removal data, you had gone through
Yes.
that. They could
Mhm.
be a myriad of different reasons. Do we also
Yes.
have the breakdown of that? And could that maybe be shared with the board? Because I think also that if it is truly like tardies, maybe
Yes,
something we can do.
I can absolutely follow up with Ms. Milner and provide you with that information.
That'd be awesome.
Absolutely.
Thank you.
Yes,
I have a question on the substance.
yes,
So obviously the spike, we're using more vape detectors nowadays, correct? So couldn't that be part of it? They're being detected, therefore they're forced to be tested if they're caught and they're positive. Can that be the uptick?
I do know that the middle school did have an uptick when the vape detectors were installed at the middle school. I can also follow up with Ms. Milner and get you more information about that. The extent to which vape detectors are used in the restrooms, et cetera. Okay, I can find that information out for
Thank
you
you.
as well.
I'll just chime in too.
I have a quick question.
But it also is representative of of its own type of pandemic or epidemic of kids getting involved with vaping much younger. And it's so addictive so early on, and not enough is being done about it, which is me editorializing in touch, but I think it's something that definitely warrants a more aggressive response, not just at the school level, but at societal.
In our conversations with Ms. Basilone as well, she also has more global research, not just specific to this place, that also underscores much of what Dr. Portis had just said as well, because there's also almost like a gap in adolescence, the period during which I'm certain I don't have a degree in psychology, mine's in literature, but there is a period in adolescence that developmentally, having to do with really trial and error, judgment forming, forming judgments, making judgment calls, that it's quite possible many young people in this age group have kind of coasted over, skipped over, and that's executive function, impulsivity, things along those lines that they're still kind of forming and developing in ways that perhaps 10 years ago or so, I'm not sure, we might have seen that differently. So I suppose we'll see it more so in the rear view, but I can absolutely, provide you with more data and follow up as well with Mrs. Basilone.
Are we
I'm sorry, are we also able to get possibly, are we looking at a specific grade level that is having more substance abuse than the other? Is that something that we could break down as well and maybe target that specific grade? Dr. Portes?
Yeah, well, internally, we do
Yes,
keep such data.
yes.
Mhm.
And it is something that we're aware that there are groups,
Mm-hmm.
whether broken down by any one of many
Mhm.
representatives. So
Yeah.
we know we need to
Yes.
focus on it. It's probably my best way.
And to add to that as well, again, Mrs. Basilone, I'm singing her praises tonight. But she has made it very much so a goal and an objective to form therapeutic relationships with students at risk. And then to also have, to have this intervention plan in place that's very granular and very specific as well. So I hope that answers your question, Ms. Esposito. Thank you.
I had a quick question for you. On your programs and trainings, I noticed that SJG seemed to
Yes.
exceed all the other elementary schools in number of programs by not a little bit. Is that in response to something or just because they're the best, as Ms. Esposito just whispered under her breath? Was that in
Yes.
response to prior incidents, or is that just, they took it upon themselves to do more than everybody else?
I am not certain of that, of the response to that. What I do know, is that, certainly Mr. Reiner, the programming that he does is instructional as well as, co-curricular. He pushes into classrooms, along with Mr. Im and does lessons that are, related to, to the subject matter at hand, and all across the year for certain. But, again, we could take a little bit of a deeper dive into that if you'd like, and find out. I think there's always good stuff that's happening that can be shared across all of the buildings.
I'm sure Mr. Reiner would love to share his
Yes.
data with us.
Yes.
Is just a follow-up question to that. Is there a minimum we expect from each school or?
Well, the state does have, and Mr. O'Keefe, who is going to be replacing me in this role in the fall, he will do the self-assessment report. The state does have minimum requirements of you, but I would say that we do try our hardest to exceed that minimum requirement, and our reporting shows that our assessments.
Yeah, I'd say exceeding it by quite a bit is the expectation. And I will commend Mr. Reiner. I think he's doing a great job emulating the former principal of Hillview. That at once reactive and proactive in his programs. And I do know that they did do, he and Mr. M did one program that was in response to data that they saw from the previous year. And they thought it was a specific need they wanted.
Thank you. Last question, and this is probably to both of you. I noticed there's a spike in alleged HIBs, maybe not necessarily HIBs. What do we attribute that to?
So interestingly, I attribute it to better programming.
Yeah.
Because if you look at the alleged spike, right, it is actually, there were a few cases that were alleged at SJG this year, right? They turned out to be nothing, but better to err on the side of caution, right? And I could say, having looked at those, certainly at those cases, they were erring on the side of caution, right? Because students know better, and that it was pursued by Mr. Reiner and his staff, as such. And it was taken through, the proper course of things. But that is where, I think the spike is attributable to that, which is a pleasant complication. Much rather that.
Yeah, and I think the public posting of that Form 338, which is allowed for greater ease in reporting for families or parents and even for students as well, has also contributed to that, because there is an awareness of this. And when those get filed, oftentimes the principals will reach out to me or to Ms. Abrams and say, what do you think of this? And there have been instances where I've said, there's no way on earth this is going to be a HIB, but we're going to investigate as such so that we have a thorough investigation. We leave the paper trail and we ensure that if there is anything similar to this involving any of the same participants, we have documentation to support that we've done an investigation and that we're monitoring it.
Any other questions?
I'm sorry, do we get a lot more referrals through that anonymous form? Or have you seen like a huge uptick with it, or it's just there?
I think it's a pretty even, no,
Like
I
an
don't see a
even-
big uptick because of that. I
Okay.
think it's even overall between if it's reported at the building level or through, the building, or if it's reported externally through that, it's probably 6 of one, half dozen of another.
And something too that I don't think it shows up in the historical data right now, because we had a few incidents a few years back that predate what was presented, where we saw retaliatory
Yes.
HIBs being filed, and things would escalate. And as we know, whenever there's action and reaction, there's no defined endpoint sometimes. So we had to investigate, and so you might see a school that had 13 in one reporting period because there was so much going back and forth. We seem to have gotten out of that. We've seen a few that, one's filed against a person and that person's filed back against them. We still see that periodically, but it's pretty uncommon.
All right,
Thanks very
thank you
much.
very much. Good job. All right, up next is our legal update.
I know.
I believe when you make a PowerPoint presentation that not all of the information that you are going to be getting should be on the slide. So I believe firmly in that. No, there will be information that I say is present on the slide, but it is not word for word. That does not bode well for me as a presenter. Let's just put it that way. No. Yes. So good evening, everyone. For those of you who do not know who I am, my name is Jacqueline Morgese. I'm an attorney with Chasen, Lamparillo, Mallon, and Capuzzo. I serve as the Board of Education's legal counsel. I've been asked this evening to give a legal update as to sort of where we are in the landscape of education law. I just want to open with sort of a broad disclaimer. I've been asked to provide a legal update. I take no position, nor do I make any opinion on any of the information that I'm giving to you. If the Board of Education has any questions or would like to apply some of the information that I am giving to you, obviously I need the opportunity to do a more in-depth factual analysis in comparison to where we are with the law. So I just wanted to give you that information as of right now. So I don't know if I know how to work this thing, but there we go. So this evening, I'm going to talk to you about 4 different topics. These are the largest, most, I would say, prominent changes in education law over the last year. You see the change in the sick leave law regarding public employees and how we apply specifically for education and teaching staff members, how sick leave applies to them. The most recent change related to the Open Public Records Act and how that's sort of changed the landscapes as far as transparency in government. Probably the most time we're going to spend on is the transgender student policy, the information related to where we are with the Hanover Park, Marlboro, and Manalapan litigations, as well as the most recent indictment of George Norcross and how that impacts health insurance. So those are the 4 topics I'm going to cover for you this evening. And if at any point you need me to repeat something, I'd be more than happy to do that. So we're going to jump right in with sick leave. 18A 30-1 is going to give you your sick leave statute. That is still the statute. That is still the statute that applies. It's just been expanded. So previously, when sick leave, prior to the July 2023 change in the law, sick leave applied exactly like that. When you were personally ill, you had the right to take sick leave. Public employees or school employees were permitted only to use sick leave when the employee was personally ill or injured, or they were required to quarantine due to a contagious illness in the employee's household. That last language about quarantine, really sort of specific to how it was diagnosed. It wasn't necessarily created because of COVID. So it was sort of misapplied during COVID times, which is, in my opinion, why the sick leave law kind of came about, because of the fact that it was very restrictive into how sick leave could be granted and applied. Not only did the grounds for which an employee could use sick leave change, but also the notification requirements. Previously, under 18A 30-4, we could request, as a Board of Education, could request a doctor's note for any period of sick leave for any period of time. So if you were out for one day for a cold, we could ask you to provide a doctor's note. Now that gave a lot of employees hangups because of the fact that employee wakes up and doesn't feel well. They're not always going to the doctor every day. So in practice, it wasn't really taking place like that, but that's essentially what the status of the law was. So in July of 2023, Governor Murphy comes in, he passes Public Law 2023, Chapter 95. This law greatly expands the uses of sick leave, as well as alternatively addressing how we require verification of that sick leave. Those revisions were effective immediately. So the law passed on July 3rd. They took effect on July 3rd. It kind of sent a lot of school districts, Pequannock being one of them, into a mad dash to make sure our policies were updated for this current school year. You guys have a current policy on the books. You took really quick action on that, followed the model policies, and that's a credit to you as a board. So by changing with Chapter 95, not only could employees use sick leave for personal illness, but they could also use it for a number of other reasons. Those reasons are listed above up there. It's not only for your personal illness, it's for the illness of a family member. Family members are defined broadly. It's for also for not only for the actual illness, but for preventative care, right? So if you go to a doctor for a preventative care visit, that's considered eligible for sick leave at this point in time under the statute. It also created a lot of situations where an employee was absent due to circumstances related to being a victim of domestic or sexual violence, in order for them to obtain psychological counseling, services from a designated domestic violence agency or victim services organization, anything sort of related to that. It also covered the opportunity for you to seek legal services to address a domestic or sexual violence incident. So again, we're greatly expanding the definition of personal illness to now encompass all these different uses. What it also did was language that was typically memorialized in an individual school district's collective bargaining agreement was now mandated statutorily. So you see throughout the state, there were a number of provisions within collective bargaining agreements where employees could use sick leave or could be granted leave for bereavement purposes. And individual districts established the relationships for which and the length of periods of time that an employee could be absent for a family member's death. This was now codified in 18A 30-1. Employees can now use up to 7 days of sick leave, specifically sick leave, for death of a family member. And again, family member is defined very broadly. Other purposes were related to children, right? We saw a really big movement in COVID where a child's school might have been closed, but the school district that the individual employee was working in might have still been open. We saw a lot of circumstances where employees were having to choose between whether or not they go to work or their child goes to school, one or the other. So I think a lot of the Chapter 95 changes were spurred by this new realm that we were dealing with because of COVID and these other circumstances that we were dealing with. But I think that that's sort of how the legislature was attempting to address it. The statute also specifically addresses certain definitions. Definitions related to who's considered a child. It can be a biological, adopted, foster child, or stepchild of the employee or the employee's spouse, domestic or civil union partner, or a child who is defined as a quote unquote legal ward of the employee. So again, very broad definition of child. Family member for purposes of bereavement is pretty much every relationship under the sun I could list them all out for you, but we'd be here forever. But it also includes a specific blanket relationship. Any employee who related by blood or whose close association with the employee is the equivalent of a family relationship. So if you have a person that you consider to be a family-like status to you, that's considered a close association under the statute. You could use your sick leave for that individual's bereavement under the statute. We also saw changes to 18A 30-4. This is dealing with notification, right? So 30-1 deals with the definition of what constitutes sick leave, and 30-4 deals with how we receive notification and accept notification of sick leave, right? Because when we had personal illness, it was you went to the doctor, you got a doctor's note, you provided a doctor's note, a doctor certified that you were personally ill, you were eligible for sick leave. A number of those reasons on the left-hand side are not something that a doctor can certify to, right? A doctor can't certify to that you've been requested or required to attend a PTA meeting or an IEP meeting at your child's school. A doctor can't certify to that. So how do we verify something to that effect? So the reasonable documentation piece is what's key under 18A 30-. Sorry, go ahead, Sam.
If it wasn't a personal illness, but it was something else, you would probably still be able to get a note for that.
If it wasn't personal illness and it was something else, you could, yes.
IEP meeting, you would get a note from the other school. If it was somebody else was sick, if your child was sick, you would get the child's sick note.
Right, but I understand what you're getting at, but the 18A 30-4 said physician certificate, so it needed to be modified
Right,
to follow it
right.
and
Oh,
expand.
sure.
the-
Or,
so on
and
so-
like you said, you might wake up in the morning, feel like crap, but I'm not going to a doctor.
Right.
Why bother? It's going to be gone in 48 hours.
Right. And I can say sort of as a general measure of practice is that if you are an employee who is not historically tardy or absent, most districts, including this one, are not going to look to you for a doctor's note on 1 day of absence. It's the individuals who are abusing these reasons that we're looking for putting sort of a stopgap, because then it becomes an operational issue, right? If we don't have the staff member in front of our kids instructing our kids, we have a disruption in the student day and we have disruption in the student learning process. And in the day and age where we're in a substitute shortage and we're in a teaching shortage, it creates an operational issue for us. But the real key is the type of documentation, the timing of the documentation, as well as the difference between foreseeable and unforeseeable absences. So for personal illnesses, family illnesses, anything that sort of involves a doctor, physician certificate is still going to be the gold standard. The timing for which is going to be a little bit different, right? So the time for which we can request a sick note for personal illness doesn't change. That doesn't get touched by the statute. That doesn't change at all. But for any of these other reasons, the statute specifically says that it can be required only after 3 days of consecutive illness when the leave is not due to the employee's own personal illness or injury. So family illness, bereavement, 3 consecutive days, that's when we have the ability to ask for you for medical documentation or some form of documentation in accordance with the statute. Examples of reasonable documentation for an individual who's a victim of domestic or sexual violence, law enforcement record or report, police report, things like that, a court order, documentation showing the conviction of the an individual who was perpetrating these offenses against the employee, and other documentation, right? The statute actually incorporates language that says you could get a note from your priest and it could be considered adequate documentation. So it's very broad. The interpretations of this language really haven't come through yet because of the fact that it's statute. I mean, if you're looking from a legislative perspective, a statute being less than a year old is a pretty young statute. So you really don't have a lot of case law to sort of supplement and fill in the gaps where there might be ambiguities in the statutory language. So we're keeping our nose to the ground as those informational gaps get filled. The other key that the statute comes in and talks about is the difference between foreseeable leave and unforeseeable leave, right? you can't foresee when your kid's going to wake up on Tuesday and feel like he's got a stomach virus and you got to take him to the doctor. That's an unforeseeable leave. The statute requires as much notice as you can reasonably provide, right? So if the kid wakes up at 7 a.m. throwing up and you got to take him to the doctor, obviously the sooner the notice, the better. But in that sort of circumstance, that's not foreseeable. It's not something that we can address. The foreseeable piece is something to the effect of you had a scheduled IEP meeting for your child at your child's school, and that was been scheduled for 3 weeks in advance. We're going to ask you for that information at least 7 calendar days prior to the date of the expected leave. So if something is foreseeable, the statute does require 7 days notice, but it does not define or provide a bright line as to what is considered foreseeable or not. My recommendation is always going to be use your best judgment as an employee. If it's something that you know about and you know that you're going to want to be absent for it, make the request as soon as you can. Any questions on the sick leave portion of this? So the Open Public Records Act is the newest change in the law. This actually came down last month. So Open Public Records Act is the law that requires public bodies to provide access to government records when they're requested by individuals or entities. The term public records is pretty broad. It's any government record determined to be available for inspection, right? So the definition is the definition itself. It's a government record that's deemed to be a government record. It's sort of circular. But there's a lot of case law, both by the Government Records Council or the GRC, as well as Superior Court cases that define essentially what's a government record and what's exempt from disclosure as a government record. Personnel records always going to be exempt from disclosure. Student records always going to be exempt from disclosure. They're considered government records, but they're exempt from disclosure. So there are a number of exceptions to that definition. So on June 5th of this year, Governor Murphy signed a bill into law that states that there's more than a dozen changes that in the general public opinion, I guess, that make the state's OPRA law more difficult for people to gain access to documents created and maintained by public officials. I actually missed a slide, so there we go. According to some critics of the bill, it cuts off access to a wide array of public documents while seeking to streamline the process for requesting records. Previously, the law was that you weren't required to use a particular form. Now there is going to be a uniform request form issued by the state that's created and adopted, or it's going to be created by the municipalities and adopted to allow custodians to deny outright requests that don't include a name, address, email address, or phone number. This is going to be really sort of important for your custodian of records, simply because some requests that come in from entities and requests pages and pages of employee information because they want to send out whatever they want to send out to as vendors or whatever it might be. It also impacts how employees or how requesters are treated when they make anonymous OPRA requests. Anonymous requests are also really difficult to respond to and address because you don't know who you're dealing with. You don't know if there's a malintent behind what the request is seeking. You want to make sure that the information that you're being requested is valid and it's something that you have to provide. And this law addresses how we do that. If you're an anonymous requester under this new law, if an individual custodian of records denies your request, you don't have standing now to come forward and object to that request or challenge that request simply because you chose to be anonymous. And a lot of critics of this law have sort of determined that or taken the opinion that that creates a lack of transparency. By nature of me being anonymous, I now don't have the right to now fight for a request for something that if I was willing to put my name to, I would have the right to be able to challenge and receive. Probably, I think one of the largest changes, in my opinion, is this idea is there are a certain number of documents that under the previous iteration of the law had to be immediately disclosed. Contracts, things that were dealt with, administrator salaries, things of that nature. Those things are only now have to be provided immediately if they're within 2 years old. So an individual, if you're looking for a superintendent's contract, you're not provided with immediate access if that contract is more than 2 years old. You can still request it, but it's not something that we have to immediately provide to you. So that 7-day response time would still apply. Things like bills, budgets, vouchers, employee salary information, overtime information, it's not required if that information is now more than 2 years old. And then also one of the more interesting things is if the agency, let's say the Board of Education, has a document, but it did not create the document, it just has it in its possession. The thing that comes to mind is a bid specification, right? Your architect would have probably created something to that effect. You have it, you have a copy of it. If somebody sends you an Oprah request for it, according to this new law, you can direct them to the architect. You don't have to actually provide it to them. So it's a time saver, right? We're looking to make this a little bit more streamlined. And then it also allows custodians of records to essentially create an online portal where they can put government records that are requested onto. So rather than you responding to an individual requester, you might put those records on this online portal so that if your memorandum of agreement with the PTEA is requested as a public document, one requester wants it, and then 2 weeks later, another requester wants it. Rather than you having to send out 2 separate requests and responses to those requests, you could put it on an online portal and say, here it is, it's accessible at this link, and here's where you can access it, and it saves you the time. So rather than you have to address that individually, you can address it as sort of a blanket repository. Yes. So that's ambiguous in the statute. My best understanding of it is that if you are aware of where it can be located, we're obligated to provide them with the route to receive it. But the law still stands that if it's something that you did not create, you're not bound to, 1, create anything, or 2, provide something that you don't have either. So if it's publicly accessible, I always recommend that it be provided as to how they can get it, whether it's publicly accessible on a website or whom they can contact to it. But recognize that once they start reaching out to these other entities, they're not necessarily public entities who have the required by Oprah to provide this request. You, as the Board of Education, if it's a record that you've created and it's a government record that you maintain, you're obligated to comply with it because of the law. Any other questions on Oprah? Probably the most controversial piece of this law is that it allows government entities to file suits against requesters if they believe that the request was filed to stunt government operations, and it allows judges to issue protective orders on public entities to prevent these superfluous or highly frequent requests. I happen to represent a number of districts where we have hundreds of Oprah requests coming in every month. And this language of this statute would serve to curb some of those requests and simply address if they're just meant to be menacing and to attack a Board of Education or other public entity for purposes of creating essentially traffic. This law would now provide those public entities with an avenue to stop that. It also impacts the law related to how special service charges get imposed, and as well as if previously it used to be only the time taken to reproduce the actual record you could charge a special service charge for, but now the bill would allow records custodians to impose special service charges on requests that they deem to involve extra time and effort, as well as double charging for any records that are made or requested that are already readily accessible in the public domain. It changes the burden for requesters who are challenging when those fees are made. So essentially, it used to be that if you were, it was a small burden for requesters to say, hey, this charge is unreasonable. Now, the burden itself is on the burden was on the government entity to show that the special service charge that it was assessing is reasonable. Now the burden is flipped. It's on the requester to show that the special service charge being assessed is unreasonable. So it's a little bit of a burden shift there. Again, a lot of critics talk about how it's impacting transparency. There's a lot of concern about how often the words reasonable or unreasonable are used throughout the statute. I mean, if you read any laws, they use that term pretty consistently, but no one ever really defines it. It's one of the first things you learn when you go to law school is that no one ever really defines what's considered reasonable or not. And then the strongest opposition to this law is the abolition of mandatory awarding of attorney's fees for parties who are successfully challenge a denied OPA request. So it previously was, if you were successful in challenging an OPA request, you could make a claim for your attorney's fees to be paid. It's a fee shifting statute. So essentially, public parties could make a request, get that request denied, and say, I want $40,000 for my attorney's fees to be paid back to me. And that was a claim that if they were successful, they had had a right to. Now, all of a sudden, it's not a mandatory fee shifting statute. There's a little bit more involved with that. And it requires a custodian to act in bad faith, unreasonably deny access, or knowingly violating the law. So it's a little bit more of an affirmative showing. Any questions on OPRA? Okay. So now we're going to get into the biggest topic, which is the transgender student policy. So this has been a long time coming. In 2017, you see that Governor Christie signed in a Senate bill. It required the State Department of Education to provide guidance to school districts on how to address transgender students. You saw a big move between the 2017 and 2018 on how to address and what policies to adopt. The New Jersey law against discrimination includes gender identity and expression and affectational or sexual orientation as protected legal classifications. So when Governor Christie came in and passed Bill 3067, it required that boards of education and public schools to create policies related to those affectational and sexual orientations, as well as gender identity or expression, include those within protected classes. 18A 36-41 is your statute that memorializes what needs to be included in your policy. Specifically calls for guidance to be disseminated to school districts regarding specific terms to be defining transgender issues, gender identity and expression, what a transgender individual is. It requires school districts to maintain a safe and secure learning environment that's free from discrimination and harassment, not only for students that are in protected classes, but specifically transgender students including students going through a gender transition. It addresses confidentiality and privacy concerns, procedures for how school records are maintained, how we maintain the official record containing the student's legal name and biological gender, all these different issues related to how we maintain our records, how we issue school documentation, how we handle physical education, bathrooms, all that stuff that we hear about when we talk about transgender students and the issues that they experience in schools. In addition, the bill that Governor Christie passed required guidance and resources to be provided to school districts regarding professional development opportunities on how to educate teachers and other school staff on concerns and issues related to LGBTQ+ students. The Commissioner of Education is particularly required to conduct periodic reviews of the guidelines and update and modify them as required. So that's why you're seeing a lot of this guidance come through periodically. Every sort of 6 to 8 months, you see something new that comes through and requires us to kind of respond to it. Where this got sort of chaotic is the adoption of policy 5756. So when the New Jersey State Department of Education provided its guidance, it tackled the issue regarding parent notification and whether or not parents should be notified, and essentially left it to school districts in their best judgment and in the best judgment of its professionals to determine whether or not parents needed to be notified. And that was sort of a very heavy buzzword for a lot of school districts. Specifically in 2023, the districts that you see listed below, Hanover Township, Manalapan, Englishtown, Marlborough, and Middletown, took actual legal action regarding the amendment or repealing of policy 5756. Policy 5756 is the Strauss-Esme iteration of the transgender students policy. That policy, as originally drafted by Strauss-Esme, again, left the parent notification process within the best judgment of school professionals. And that was sort of interpreted as to mean that a school district was not required to notify a parent as to a child's chosen name, gender identity, or how that child wished to be referred in school. So again, those four districts, the four districts that are the main sources of this litigation, because they took specific action either to repeal, amend, or pass other policies related to the parent notification process. Policy 5756 specifically states there is no affirmative duty for any school district personnel to notify a parent or guardian of the student's gender identity or expression, except when mandated under specific state or federal laws. So I'm going to give you a summary of each of the four districts and sort of where we are in those pending cases. So in Hanover Township, they passed a policy called 8463. What it requires is the immediate notification of parents when a staff member is made aware of facts and circumstances that could impact students' overall health and well-being related to the student's sexual activity, orientation, transitioning, gender identity, or expression. The 8736 allows staff members to notify the administration, DCF, DCP&P, or the Hanover Township Police if they believe that parental notification will place a student at risk or abuse or neglect. So essentially what they were requiring is mandating that parent be notified, but then also empowering individual staff members to report if they believe that that mandatory notification was going to create and put a student in danger. Middletown's policy required parent notification when a student requests a public social transition accommodation, provided there's no documentation or evidence that doing so would put the student in physical or emotional harm or abuse. And then in the Middletown policy, parental notification was only required for counseling and a referral to the student's mental health concerns relating to parent notification, consent for such services. In Manalapan, Englishtown, it was similar to the Middletown policy, except it sort of broke it out into grade levels. They made a determination that if you were a student in grades pre-K through 5, the responsibility for determining a student's gender identity rests with the parents, whereas from grades 6 through 8, parental consent for acceptance of the student's asserted gender identity is not required. The policy would also require parental disclosure if there was no credible evidence that doing so would subject the student to physical or emotional harm or abuse. Again, these policies, these are the language specifically from the policies. I don't have any more information as to what's considered credible evidence specifically related there, but I wanted to give you sort of an overview of these policies. The Marlborough policy focused on addressing case-by-case transgender issues. And then that policy required a duty to notify parents, guardians of student changes in gender identities or expression, except if there is reason to believe doing so would pose a danger to the health or safety of the student. So when these districts everybody kind of took the same scope of actions around the same time. Last summer was really sort of when this issue kind of came really to a head. The day after Hanover Township passed 8463, the Attorney General filed and the Division of Civil Rights filed both a complaint in Superior Court as well as a complaint with the Division of Civil Rights. Both complaints allege that the board's action unlawfully discriminated against transgender students or students who were questioning on the basis of gender identity or expression or affectational status or sexual orientation. The grounds were it was a violation of the New Jersey law against discrimination. So with any sort of legal case, when a complaint is filed, there's the opportunity for either entity to seek what's called temporary restraints. What temporary restraints are is the opportunity for the party who is opposing the action to be taken to put a temporary stop on that action and essentially maintain the status quo during the pendency of litigation. So on August 24th, 2023, the Superior Court of Morris County issued temporary restraint stopping the enforcement of revised policy 8463. But then the board came through and they, while they didn't adopt 8463, they repealed 5756. So the policy that applied related to transgender students, they pulled that back. They did not, were temporarily restrained from adopting policy 8463, which was the policy that required parental notification. And that was, everything sort of remained in a status quo for about a month until the court issued an order. They granted the Attorney General's and the DCR's motion for preliminary restraints in part. They temporarily restrained them from adopting policy 8463, determining that the parental notification process could not be adopted, but did not stop them from rescinding policy 5756. So that case is currently on appeal. Essentially, the court had a split ruling. Where it sort of boiled down is the parental notification process and mandating parental notification could not be adopted by board policy. The repeal of 5756 could be allowed to continue because the court sort of opined that the New Jersey law against discrimination is the law of the land. And because it's the law of the land, Board of Education, no matter what their policy manual says, cannot discriminate against any individuals in a protected class. So essentially, the court ruled that regardless of whatever the board's policy manual says, Board of Education can't discriminate against individuals, particularly of individuals of on the basis of gender identity, gender expression, affectational or sexual orientation, because that would violate the NJLAD. Middletown, Marlboro, Manalapan, Englishtown, they're all sort of very similar because they adopted amended versions of 5756. Hanover Township, so that's the difference, right? 8736 or 63 was a different policy. 5756 was a policy already on the books. These three districts wanted to amend or otherwise repeal 5756. The court in Hanover came in and said, okay, that's fine. You do what you want with your policy manual, but you still have to apply the law of the NJLAD. The 8763, which was the mandatory parental notification requirement, that's the piece that's being held on. That's the piece that we can't, according to the court in the case law that's currently being in existence, mandatory reporting to parent notification is sort of in limbo, and it's been held as to be in temporary restraints in all of these cases. So that's the difference there. Any questions on this? Yes. I wish I had a better answer for you than I don't know, because I don't know. Appeals process, particularly with cases that are so high profile of this kind, they slow play it because they want to see if there's something that comes from up high, the federal government regulation particularly. My understanding is that nothing has been coming, so they're sort of determining whether or not they need to act on this. You probably will see a briefing schedule in the next couple of months, but I don't expect this to be resolved in a year or so. Any other questions on this? Again, like I said, this is purely informational. It's not meant to provide any sort of legal advice or opinion. If the board has questions on what it needs to do, we can have that conversation separately. I just want you to have all the information. I just want to make sure we talked about this. Yeah, we did. This is the fun one, because this just happened literally last week. So to give you sort of an overview, right? In 2020, Chapter 44 for health insurance comes by. And what Chapter 44 does is if you were in the school employees health benefit plan, there were about, before Chapter 44 comes into play, there was about 16 different plans that a school district could select that members could enroll in, right? It ranged from Direct 10, Direct 15, 20, 40, all these different things, and every sort of plan was separate. The thing about the school employees health benefit plan is while it is the public plan, it also drives the market for all the private plans, right? So all these other insurance companies that underwrite these plans and provide these health insurance plans to public entities, particularly school districts, is they sort of have to mirror the school employees health benefit plan and be competitive, because at any point in any time, a school district that's underwritten by Aetna can decide, you know what, Aetna's not giving us a good renewal policy anymore. Cost of health insurance is going up. We could go to the school employees health benefit plan and get the equal to or better than letter from our broker and move everybody from a private Aetna plan into the school employees health benefit plan, make that change, boom, bang, we're saving $100,000 a year because of the fact that the premiums are less. And that was great, right? Everybody sort of knew what they were getting with the school employees health benefit plan. Everybody sort of knew what they were getting with the private plans, and they sort of mirrored one another. Well, Chapter 44 comes in and it does exactly that, except in reverse. So all of a sudden, all these extra plans that were available are now gone. And there's the Direct 10, Direct 15, New Jersey Educators Plan, and the Garden State Health Plan. There's 4 plans. But now also, school districts that are not in the school employees health benefit plan have to adopt the private equivalent of the NJEHP, the New Jersey Educators Health Plan, and the Garden State Health Plan, the GSHP. What those plans are is essentially it changes the way that employees contribute to their health insurance, right? So instead of they're contributing by a percentage of their premium, they're contributing a percentage of salary. So we're not going to get into how that impacts the school district, but the problem is, or not a problem, what's most interesting is that the statute of Chapter 44 specifically requires boards of education that are not participants in the SEHBP to adopt a plan that they didn't create, right? The legislature essentially created what the policy limits and what the requirements and the co-pays and co-insurance and all those details related to the EHP. They essentially created a roadmap and handed it to the school districts and said, okay, now your private insurance carrier has to adopt this plan and has to give you a price and a premium cost for that plan. Well, we know who writes the Chapter 44 law in the state of New Jersey, and it's the health insurance lobby, it's the NJEA, and it's all of these entities that come in together and they create this body, and they're part of the Health Insurance Commission. So one of those entities that's part of the health insurance lobby is Connor Strong Bucklew, which is a major health insurance broker primarily based out of South Jersey. If you're familiar with Brown & Brown benefit advisors, they're the equivalent of Brown & Brown for South Jersey. George Norcross is the executive vice president of, or the head of Connor Strong Bucklew. So he's probably considered one of the highest power brokers in the state of New Jersey. There are people, and I won't give you my opinion on it, who believe that George Norcross particularly wrote Chapter 44 and the SEHBP Educators Health Plan and Garden State Health Plan. So not only did he create the plan that was in effect for the public plan, he created essentially the plan that every school district in the state has to adopt. And why is that important? Well, he got indicted last week on 13 counts of fraud, including racketeering. So the reason that this is important for you is because we don't know how this is going to impact the market, right? Because every school district in the state that has to adopt this plan that was written by the New Jersey State Legislature and George Norcross, now we don't know what that means. So it's going to be really interesting to see how this ongoing criminal action impacts the overall market for public employees' health insurance. In New Jersey, yeah, specifically. Any questions? But yeah, so it's just an interesting tidbit that when you saw come across your News 12 screens, everybody kind of looked and were like, I've heard that name, but I don't really know why it's important. But yeah, it's pretty interesting. So thank you guys for your time. I really appreciate it.
Thanks, Jackie.
Jackie, thank you for a great presentation, very informative. All right, moving on with the meeting. Up next, Mr. Gibbs, do you have a report?
Yes, good evening. Tonight's board agenda, there is a motion for the cancellation of the RFP for the 2024-2025 before after care program, as the board would like more input from the community before making a final decision. The before/after care program at Hillview will change from the 24-25 school year, as the Adam and Danielle Children's Center, who runs the current program, has elected not to continue next year. Subject to tonight's board approval, the Boys and Girls Club will operate the program at Hillview for the 24-25 school year. A new RFP will be going out during the 24-25 school year for the 25-26 before and after care program. I'll be sending out a survey to the community for their input prior to the RFP. More information will be provided at a later date as it becomes available. Just to give an update to the board office property will be sold on or about February 2026, as the post office, who owns the building on the property, has said that they're going to exercise their right to purchase the property. That being said, the board office will have to be moved to another location. In the search for the property in town, there is a building with property located at 7 Industrial Road that is up for sale at a price of $2,850,000. The building was built in 2006 and currently has a third floor available that could be subdivided into a board office and classrooms. The remaining of the offices in the building are currently being leased, of which the last lease will end on or about 2029. Dr. Portis, Ms. Bronco, Mr. Anderson, and I have visited the building, of which we all agree that it would be perfect converted to classrooms over time. Our architect feels that this is an excellent alternative to putting an addition on the school building, as the cost would be well over $8 million through a referendum, as this would be a tremendous savings. The board may be looking to purchase a building without the use of a referendum or financing. More information will be provided at a later date. This is just a reminder that we are in the process of setting up the October 2024 New Jersey School Boards Workshop and early registration, so we will need to know how many board members will be attending. This year, the dates are Monday, October 21st to Thursday, October 24th. And finally, the 10th town meeting will be held on Tuesday, July 30th at 7 p.m. located at the high school auditorium. The town meeting will be the Zoning Board of Adjustments meeting regarding the approval of One School Global's new facility that will be located across the street from the high school. Thank you.
Thank you.
I have a question on that. So Gordon, just for everybody, and so there's not blow-ups on Facebook. If we were to purchase this location or a different location or whatever the case may be, the money eventually would come from the sale of the property, the current property. We wouldn't have to go for referendum. We wouldn't have to raise taxes or whatever. As far as we know, it would be from the purchase of our property to get the new property.
Correct. That's what we're working towards. That's why you also see there's a motion for an appraiser to give an appraisal as to what the property is worth over where the board office is. That'll help give me an idea as to how much money we will possibly get from that property, plus how much money we will need from an SDA grant, which we are in the process of completing in order to get a $1.7 million that's due us going back to 2014. So between those two, we should be able to, I'm hoping, pay cash basically for the building and not have to go out for referendum.
Maybe, hopefully there'll be some other areas that are available too then.
Yeah. Absolutely.
Yeah, so my question was going to be, in recognizing that this is very, very early in the process and no decisions are being made, do we know what the flood history and forecast is for that property? Because it's behind Jersey Johnny's, basically, right? So.
Correct. The building is actually built in case there is a flood. There is no first ground floor. It's actually a flood zone down on the ground floor. There's also like I'm going to say a moat around the building. So if water were to come down or come into the area, it will go to that moat, I'm saying, and going out to the river. And there is actually a floodgate which will not allow the water to come back. So it'll go out and be gone. In talking with our architect, who's very familiar with the building, he said that you most likely won't have a problem with the state, because that was one of my concerns as I built a school in Fairfield a number of years ago, and that was a huge concern. I had spent many, many days down at the Department of Environmental Protection going over different ways to get around this one problem. So, yeah, so it is a positive move forward in this building. Yeah.
Just a follow-up question as well, not so much on the environmental aspect, but the road itself, industrial, as it denotes, is an industrial street. There's lots of traffic of industrial nature. For this property or any other property, will we be doing a traffic study to make sure we have, the appropriate for obviously not so much for the offices, but if we are to bring in classrooms into the space, then it's inappropriate.
Yeah, that'll actually be taken care of by our architect, but that's actually down the road. Right now, we're just finding out if it's even possible to do this. So we're at the very beginning stages, which is a good reason why we're starting early. Because you don't want to get to the last minute and have to mad scramble and find a facility for the board office. Yeah. Okay.
Thank you. I guess something you want to
Don't deny me my vote.
Mr. Gitten, will you please?
You will
move the
not allow
minutes?
to have a bridge though. No bridge over the moat.
Mr. Gitten, will you please move the minutes?
Yeah, I'd like to make a motion to move the minutes for the May 28th meeting and the June 10th meeting.
Second.
Question or discussion? Mr. Gibbs, please call the roll.
Mr. Bloomer,
Yes.
Mr. Cerisi,
Yes.
Ms. Dempsey,
Yes, to May 28th, I'll abstain on June 10th.
Mr. Gitten.
Yes.
Mr. McSweeney,
Yes.
Mr. Pompeo,
Yes.
Mrs. Shenton,
Yes.
Mrs. Esposito,
Yes.
and Mr. Senick.
Yes.
Motion carries.
Thank you. That brings us to our first opportunity for public comment. Members of the public may speak once for a maximum period of 5 minutes by the clock during this portion of the meeting. Public may speak on any agenda item only during their 5 minutes, and if a member of the public does raise a question, the question should be directed to the board president. Please state your name and sign in before you begin. All right, seeing nobody with any questions, I'm going to close that and move on to approval of our action items. Mr. Cerisi, would you please move the items under PMC?
I would like to move PMC 297-24 through 350, PMC 352-24.
Second.
Any question or discussion?
Yes. Real quick, a couple of these resolutions have Dr. Sheridan listed.
Correct. I was trying to employ a coercive tactic to make her stay. No, I'm kidding. So my logic there is to do the approval through June 30th for the associated positions that come with being the director of CNI. And then when we move forward with the replacement in August, either the interim person will take those over if we have to go that route, or if the person we look to appoint can take over, we'll just give it directly to that person. So I figured it's cleaner to have somebody on the books, despite the fact we know she's retiring in 2 months.
Thank you.
Okay, Mr. Gibbs, please call the roll.
Mr. Bloomer,
Yes.
Mr. Cerisi,
Yes.
Ms. Dempsey.
Yes.
Mr. Gitten.
Yes.
Mr. McSweeney,
Yes.
Mr. Pompeo,
Yes.
Ms. Shenton,
Yes.
Mrs. Esposito,
Yes.
and Mr. Senick.
Yes,
Motion carries.
thank you. Mr. McSweeney, would you please move the item under? Go ahead.
Yeah, I'm sorry to interject, but I just want to point out that in regards to PMC 306-24, which is the appointment of our new English language arts supervisor, she's present in the audience right now. So congratulations to our soon-to-be new supervisor, Ms. Alyssa Bellardino. Congratulations.
Okay, Mr. McSweeney, please move CIS.
Yes, I'd like to move CIS 109-24 through CIS 112-24.
Second.
Question or discussion on CIS? Mr. Gibbs, please call the roll.
Mr. Bloomer,
Yes.
Mr. Cerisi,
Yes.
Ms. Dempsey,
Yes.
Mr. Gitten.
Yes.
Mr. McSweeney,
Yes.
Mr. Pompeo,
Yes.
Mrs. Shenton,
Yes.
Mrs. Esposito,
Yes.
and Mr. Senick.
Yes.
Motion carries.
Okay, that brings us to FFA. Mr. Bloomer, would you please move FFA?
Yes, I'd like to make a motion, to move FFA 177-24 through FFA 212-24.
Second.
Question or discussion on FFA?
I just have one comment on FFA 20124. I just wanted to personally thank the staff of the Adam and Danielle Children's Aftercare Center for the many years of service that they've provided to our district. And for the excellent care they have taken of my children, and I know of many others in the district. And I greatly appreciate that I was able to be a working mom because of them.
I would like to second that.
Okay, Mr. Gibbs, please call the roll.
Mr. Bloomer,
Yes.
Mr. Cerisi,
Yes.
Ms. Dempsey,
Yes.
Mr. Gitten,
Yes.
Mr. McSweeney,
Yes.
Mr. Pompeo,
Yes.
Mrs. Shenton,
Yes.
Mrs. Esposito,
Yes.
and Mr. Senick.
Yes,
Motion carries.
thank you. Ms. Dempsey, would you please move policy?
Oh, motion to approve P 17-24. Sorry, I didn't hit the button.
Second.
Question or discussion? Mr. Gibbs, please call the roll.
Mr. Bloomer,
Yes.
Mr. Cerisi,
Yes.
Ms. Dempsey,
Yes.
Mr. Gitten,
Yes.
Mr. McSweeney,
Yes.
Mr. Pompeo,
Yes.
Mrs. Shenton,
Yes.
Mrs. Esposito,
Yes.
and Mr. Senick.
Yes,
Motion carries.
thank you. Mr. Pompeo, would you please move other?
Absolutely. I'd like to move O-13-24.
Second.
Question or discussion? Mr. Gibbs, please call the roll.
Mr. Bloomer,
Yes.
Mr. Cerisi,
Yes.
Ms. Dempsey,
Yes.
Mr. Gitten,
Yes.
Mr. McSweeney,
Yes.
Mr. Pompeo,
Yes.
Mrs. Shenton,
Yes.
Mrs. Esposito,
Yes.
and Mr. Senick.
Yes.
Motion carries.
Okay, that brings us to our second opportunity for public comment. Members of the public may speak once for a maximum period of 5 minutes by the clock during this portion of the meeting. A member of the public may speak on any topic during the 5 minutes, and if a member of the public has a question directed towards the board president, state your name and sign in before you begin. Oh. Seeing nobody, I'm going to close public comment and move on to unfinished business. Anybody have any unfinished business?
I just have one item because I was not able to be at the workshop meeting for the policy discussion. So regarding the homework policy, I know that the admin is going to be discussing updates to that at their retreat coming up in July. We have piloted the homework free weekend in May, so we got a little bit of a taste of that, I suppose. But I wanted to just put it out there in case anyone wants to share thoughts on what you'd be interested in having the administration consider in reviewing this policy, or if there are any particular priorities that you want them to, think about or discuss. I will mention, I think dedicated homework-free weekends or holidays or something along those lines are important. I would like to see that institutionalized in some way, whether it be through the policy, or I've actually been seeing in other districts, they put it on their district calendar, although it's not in the policy. So Princeton Public Schools have them calendared right in. Ramsey Public Schools are doing this. So that's another great way to really communicate that it's something that's a priority for us. So that I just wanted to put that as something I'm hoping will be discussed, and I'll open it to the floor if anyone else wants to.
Megan, I'm sorry, just a quick question. Do you know, just because I know part of the concern here is that we do have AP classes for the high school.
I'm pretty sure Princeton Public Schools are offering AP.
Yeah, I'm sure.
classes.
Do we know, is it like universal? I mean, is there something different for their AP classes? Because, I 100% agree with homework-free weekends. Absolutely. However, having a child who went through AP World History, there is a tremendous amount of curriculum that has to get done before that AP exam. Though I think it would be beneficial maybe to have like less work for AP that weekend, or if we could, because I know that is a concern, not only for the teacher and the staff, but for the kids and the stress of getting all of that information. Just how are other districts handling that handling those AP courses?
So I don't know, I can't answer that, but just not problem solving, but I do tend to like to problem solve. I would think maybe you give an assignment Wednesday through Wednesday as opposed to Monday through Monday. Monday through Monday, then come Saturday, Sunday, the kids are like, oh, I have to do it. Wednesday through Wednesday, perhaps they decide to work on the weekend, or perhaps, Monday and Tuesdays when they focus on it. So I think it's just maybe about how the work's distributed. Thank you for bringing this up again, Mrs. Dempsey. I think it's so important. I know that we talk about stigma-free and mental health, and I think this is such a critical component to that. I know we were able to do one this past year. I also hope that we're able to implement on a much more frequent basis going forward.
I agree with, my daughter just graduated, had a number of AP classes in her senior year. And, the mental health aspect of this is really important. Having that free weekend to not have to be buried in your books is really important. We're not asking that we spring this on the faculty and the staff and the students, last minute. We're saying, let's get this on a calendar now for the next year. So the AP teachers know this second weekend of whatever month or whatever the plan is, they have plenty of time to say, okay, we're going to do our project the second week, not the third week, and give these kids a break, because they do need it. Because it as they go through high school and they're going through, AP classes and worrying about colleges, and it mounts. The pressure really gets to them after a while. So give the teachers a weekend off too.
Yeah.
They don't have to answer emails and answer questions from students who are trying to figure out how to get this project done in time. I like it.
I think it's an interesting timing opportunity, because I would imagine that many teachers are already rethinking, how am I going to deliver a lesson in this longer block of time versus a shorter block of time, right? So you're sort of already thinking about the curriculum delivery. So again, like you said, Mr. McSweeney, with that advance notice of such a weekend, maybe there's a chance to kind of intentionally figure that out. Danielle, to answer your question, I didn't notice any kind of caveats written into the ones where I saw it on their calendar. I admittedly did not see it in any policy that I looked at. So that does not seem to be a trend. But the ones that did have it on their actual district calendar, just like their half days and their days off, they had homework-free weekends. I think one of the districts, it might have been Princeton, it was all holiday weekends. So it wasn't like necessarily one a month, but it was the Thanksgiving recess, it was the Martin Luther King recess, whatever those holiday weekends were, those were the homework-free ones. So it's being done in districts in ways that make the most sense for them. And I trust that Dr. Portis and his admin team will also make the right decisions for us.
Yeah,
Maybe
I was
that's it.
going to say, I think that this is important, but I certainly wouldn't want to hold anybody to, it has to be once every 2 weeks or once a month or whatever. Again, Dr. Portis and his team, they figure out what it is, what works for them. And the kids and the parents can work around it. I mean, if they're going to know that they have, there's no homework on Thanksgiving weekend, then they're going to know that in September. So, they can work around that. But I do think it's important. And honestly, I think it's important for the teachers, because if the teachers know that they don't have anything that they have to worry about over Thanksgiving weekend, I think that that's important as well. So.
Not quite along these lines. I know other school districts are doing not just homework-free weekends, but allotting time, maybe once a marking period, once a quarter, to, instead of going to classes, allowing that to be one-on-one time with, let's say, an AP teacher for follow-up, where students can schedule that. I think that may be even more valuable, because it allows them to really say, hey, this is where I need help. We need to focus on these projects, and circling back with check-ins. So something along those lines, but maybe more work oriented, not to sound like it needs to be more work, but something where they can actually go and get the special help they need, as opposed to just time off.
Okay. Anybody have any new business they want to bring up? Board member announcements?
I have a few, Mr. Senick. So I attended the June 12th Morris Educational Service Commission meeting. It was the annual reorganization. It's on a different schedule than we are. So we reorganized the board for the 24-25 school year. Is that right? Yeah, 24-25. Crazy. Yeah, and I am continuing to be on that board, so good news there. The school that the MRCSC runs is down to 20 students now. So we're continuing to look at other options, other services that the MRCSC can provide to its members, the county basically, and some other towns from other counties. They do still do a lot of the busing and a lot of the busing routes as we take advantage of as well. I had the opportunity to work the barbecue at the senior barbecue this year. That was a lot of fun. It was very hot, but I probably singed some arm hairs on that grill, but it was a lot of fun. It was great seeing the kids and catching up a lot of the parents who were there too, who I haven't seen in a few years. And then PTHS graduation was the following night. It was a great ceremony, very, very warm. But it was a good time to be there and I had a lot of fun.
I attended the PV and PTHS graduations. I thought they were both outstanding. It was very warm, but listen, you gotta do what you gotta do. We've all had lacrosse and softball games and everything else. Try going to a volleyball game in the gym in September. It's nothing. And graduation was nothing compared to that. So I echo what Dr. Portis said about the behavior and just the overall feeling. I thought it was great. I was a little disappointed that there were no beach balls or anything anywhere, but other than that, it was great. It was great. Both nights were excellent.
I too attended the PV graduation. Unfortunately, I was unable to attend the high school graduation, but I just want to thank the staff, the custodian staff, everybody who made this graduation. It was smooth. It was quick and short for the reason of heat, and everybody did a great job. And congratulations to all the graduates. And I hope everybody has a safe and happy summer.
I attended Hillview moving up ceremony, the PV graduation and the PTHS graduation. All were absolutely amazing. I did not think it was that hot. I thought it was not that bad. It wasn't that bad. It was, listen, I think our outside ceremonies, I've gone, in my district, we have one inside. I think the outside is so much nicer. I think the pictures are amazing. The kids have so much fun when they're outside, throwing their caps. It's just really awesome. Always happy to go and attend. So proud of our graduates. I also attended the PTHS winter competitive cheerleaders held a fundraiser here on the football field. They were working with mini cheerleaders. So first graders through 8th grade. They did a cheer clinic for 2 afternoons on Thursday and Friday, and then had a performance. And the minis will be cheering on the sidelines during one of our home games. It was really great fundraiser. I think there was like 60 mini cheerleaders. They had such a good time and we got a lot of compliments on the high school cheerleaders, how wonderful they were with the girls, tons of compliments and how much fun the minis had. So I was really proud of our students for, having little kids look up to them. It was a great fundraiser.
I also attended the PV middle school graduation. Was unfortunately not able to make the PTHS graduation, but it's a wonderful event. But I wanted to make sure we took a special moment to thank our volunteer EMT squads who attended both ceremonies, and especially for some people who felt like it was hot. It was nice that they were there to assist if needed, and also give special shout outs both in person and over social media to their members who graduated both middle school and high school respectively.
At a previous meeting, I had neglected to mention that in May, the end of May, I went to the Allied Health poster sessions. So it's a little late, but I just wanted to mention how impressive the students were at that, and their level of sophistication and preparation to be able to speak to total strangers about the project they're working on is amazing. And they had really ambitious research projects. So a couple of years I've gone to that. It was really impressive. I did go to the annual Hillview Quidditch match, which is an unmatched event in my mind. And want to say congratulations to Ellie DeNoya, who set a new school record, I believe, for her accelerated reader points, something along those lines. So congratulations to her. And I also attended the SJG fifth grade recognition ceremony. And they mentioned that the whole thing is planned and scripted by the students. They really do an amazing job with that. I had gone last year also. And now that was a hot day. That was that Monday morning. It was like 90 degrees by 9 o'clock. And those kids were so composed and put on such an excellent celebration. And they did it so maturely and so well. It was a really nice time. And then same comments about the other graduation celebrations. It's always a pleasure to celebrate our students at the end of the year.
Also, I wanted to thank Dr. Portis. I know that we moved the graduations from 7 to 6 this year, but I had many people coming up to me and thanking us, Dr. Portis, you. Evidently, some schools were doing theirs at 10 a.m. and 3 p.m. and other nonsense. And so I wanted to thank you for keeping things, so that parents could get to see their kids graduate. I don't know how you do that at 10 a.m. unless you get a doctor's note that you're sick. But again, common sense prevails in Pequannock, and I wanted to thank you for that.
Well said, Sam.
Imagine graduation.
Okay, anybody else? I think that was everybody. All right, that brings us to the close of the meeting, an executive session. And we do have a reason to go into executive session tonight, where we will discuss the CSA evaluation. Okay, and student matters. No action will be taken, and we will adjourn from there. Our next meeting will be July 22nd here at the high school. Is there a motion to go into executive session?
Motion.
Is there a second? Is there a second?
Second. Yes.
All in favor?
Aye.
Any opposed? Good night, everyone.